All right. All right. Well, good morning. Happy Friday. Thanks so much for being on today's topic. We're going to be diving deep into the buyer representation agreement, better known as the BRBC. Okay, so some of the issues and practical solutions. I get quite often a lot of questions regarding the buyer representation agreement. When do we initiate? When do we actually get the buyer to sign off on it? So we're going to dive into that conversation. I believe there's about 14 slides regarding this, and it's a really just a dive deep conversation of what I'm seeing based on this. And a lot of the information that I gather is straight from the California Association of Realtors as well. If you're a member of the association, you have access to all of these tools and trainings and educational platforms to better enhance your position when it comes to working with buyer sellers. So today, as I mentioned, we're going to dive into the BRBC. All right, so why this matters, right? So all of this kind of stemmed back in August 17th of 2024. If you remember, we were already having conversations even like in May, June, and July that there was going to be some big changes happening, right? And we didn't know what to expect because prior to August 17th, if you recall, the MLS had compensation. The listing agreements had cooperating compensation agreement, meaning that we were negotiating on behalf of the buyer's agent commission as well. So a lot of you that had started in real estate after 2024 probably didn't know all this. But prior to all this, we used to negotiate total commission, including the buyer's commission as well as part of the package deal. We would go to the seller, do our listing presentation, and then ultimately say what would be the commission. My commission would be 2.5%, but we would also talk about that we are going to put it on the MLS and we would offer compensation to the buyer's agent, right? And we would say commission as part of the conversation. Well, August the 17th is a day that changed everything, right? That's when we heard about the National Association of Realtors settlement. The written buyer agreement required showing residential property, right? A lot of agents didn't even use the BRBC as part of their practice. It was kind of a loose agreement. Some would, some wouldn't. So the essence is all of that change back in 2024 that is now a requirement. Now, the settlement was very concise and straightforward, saying that anytime you're talking about any real estate conversation, you must have a buyer representation agreement. Well, in January 1st of 2025, the California Association of Realtors came in with additional language that requires when it's at the earliest practical time. Okay. And please, if you're on Zoom, make sure you mute yourself. Let me go ahead and do that now. So 1 second. Okay. So in January 1st of 2025, they tweaked it a little bit because a lot of agents were complaining is, so you're saying that I have to, right, uh, get a buyer representation anytime I'm saying real estate, even at an open house, right? A lot of buyers were like, they're not going to sign any agreements. So therefore, this is where they change the direction of the buyer representation agreement, and therefore added the language that when it's practical. So the DRE's position is really an assumption at the earliest practical time means before actually showing a property, right? Now, again, everyone has their own dilemma and situation and how they see this, right? But the BRBC is no representation, potentially no commission. And again, now with all of the STEMs can be a possible DRE disciplinary action to if this goes sideways, right? So the essence of why we're having this conversation today is to really equip you and arm you with the right approach and also to be in compliance when it comes to representation of buyers. The three biggest problems that we're seeing is they're not signing a buyer representation agreement, right, before showing a property. Increased compensation after a seller offers more than the agreed upon. And I'll dive deep into that position shortly. Buyers are changing agents without properly terminating the agreements, right? We're seeing a lot of consumers not happy with one agent and they are going with someone else, right? There has to be a proper process. And we as real estate agents have to also educate our clients on the do's and don'ts. Because let's just say that you do have a buyer sign an agreement with you, and then they go MIA with you. They disappear. You're calling, you're texting, you're sending emails, no response. And then out of the blue, you connect with them. Somehow they answer your phone and they tell you, by the way, I already bought a property a month ago. And that happens quite often. So when you have the foundation and the proper approach and how you navigate the conversations, set the expectations. Okay. Set the expectations and what you're doing. One second. Let me make sure if everyone. Okay. Thank you. So setting the expectations right from the very beginning when you consult with the buyer, then they understand as much as you understand. It's a give and take. The problem is a lot of agents are not properly explaining the initial process. And what happens is when this buyer leaves to go and work with someone else, you're on the hook. The buyer would be responsible to possibly be paying two commissions, right? I just had a situation that happened with one of our agents, and the buyer ended up going and buying the property directly with the listing agent. We had a buyer representation agreement. It was still intact with the time within the time frame of the expiration date. And the buyer ultimately bought the property that the agent, the original agent, showed, but went with the listing agent. The buyer ultimately closed successfully, and the agent that originally had the agreement in place found out because she did a little bit of a research and realized the property that I showed you, their names were on title. So she reached out to us asking for assistance and guidance on this and how we can approach this because she had a legitimate buyer representation agreement. So after doing our due diligence and really thorough investigation on this, we found out, yeah, there was a valid BRBC. And therefore, we ultimately pursued what was part of the agreement. So after back and forth several months, we weren't able to connect with the buyer. But then eventually, we sent out a certified letter to the home address. She ended up sending an email, and then I ended up sending an email, and it was a very thorough email acknowledging and holding the buyer responsible for damages. Finally, the buyer responded back, and that started the dialogue. And to our surprise, moving forward, we came to a settlement agreement, and the buyer ended up paying. Now, the commission was about, I don't know, about $22,000 to $25,000 if she would have represented the buyer on that transaction. Remember, she helped show that property, and then the buyer ended up talking to the listing agent, and ultimately the listing agent ended up selling the property to the buyer. Okay. So there's 2 points to this position, right? One, agents are not holding themselves accountable to respect other agents via representation agreements, right? So there's ways in how you can navigate that, right? File complaint and ultimately go after the buyer for compensation. This is the reason you have these agreements in place to protect your time, effort, and energy, guys. But if you don't have an agreement in place, then it's going to be very difficult and challenging to try to go after compensation. This is why it's crucial and important. So let's go into the reason you don't have a signed BRBC before showing, right? Many agents still show homes first, explain paperwork later, and hope that the buyer will sign after viewing the properties. This pattern creates an enormous issue in financial risk, right? Because again, your time is valuable, ladies and gentlemen, and I get it. You don't want to upset or force anything to the buyer. But again, what's your time? You know, Going and showing a property, let's just say on a Saturday morning or Sunday afternoon, can be time consuming, right? Even just showing 3 to 4 or 5 properties can be almost half a day, if not more, right? Scheduling, right? Showing the property, spending time looking at the property, right? Then going outside talking about what your thought about the property, right? And all of that is part of the process as real estate professionals that we are, right? But if you don't have an agreement, what's the likelihood, right? It only takes them to go to one open house that you're not hosting or you don't know of, and that listing agent that is hosting that open house hooks them. They love the property. The dynamics are there. What's to say that that buyer doesn't work with that agent? Because the first thing every open house agent is doing, asking, are you working with an agent? And if the answer is yes, what's the follow up? Do you have a signed agreement with them? And if the answer is no, that's a problem, right? Because that now opens up the opportunity for the agent saying, hey, okay, I can address any questions you have. Are you interested in this property? You can go in so many different levels now to really secure that opportunity. And it happens quite often, ladies and gentlemen. So the essence is be proactive. And if you're going to be working with buyers, consult with them immediately and get the buy-in and the reason behind them signing an agreement. Okay. Before you go out and show a property. Okay. Don't do the paperwork after. Do it before. That's part of your process. Okay. Because we see this quite often. And the problem is, once that buyer doesn't have an agreement, it's open for any agent to go after your client. Well, I trust my client. I believe my client. My client is very loyal. Look, at the end of the day, it's not about being loyal. It's not about you having a good dialogue, or they may be friends. I've seen so many times agent says, I represent my client that is a friend of mine, but they end up going with someone else. How do we hold them accountable? The way we hold them accountable is having the written agreement in place that secures a written statement that says, I will represent you. And in return, you're going to allow me to represent you as well. It's a mutual agreement between the buyer and yourself as a real estate professional. Okay. Times have changed, ladies and gentlemen. Back 5, 10 years ago, it was a loose agreement. Some would use them, someone wouldn't use it. But you were taking a gamble as well if that buyer was going to be working with you and they were actually loyal to you. It has nothing to do with loyalty anymore. It is now part of the practice, and it's part of the law now that any time you're working with any buyer, regardless if it's family, friends, colleagues, or people you don't know, you must have a written agreement. Okay. The Department of Real Estate is really cracking down on all of this stuff. And I want you to understand the initial process. Okay. The problem is we don't want this to happen where you put all the time, effort, and energy, ladies and gentlemen, and now the buyer goes with someone else. That's a lot of money that you're letting go, right? At least if you have a buyer representation agreement locked in and secure, now gives us a little bit more ammunition to go after the buyer and hold the buyer accountable to doing the right thing. Okay. So it's best to go in that direction because now we have an anchor that we can really push hard to go and work with this particular buyer or at least go after compensation. What can go wrong? Yeah. I like Mark chuckles on that. So operating without a signed BRBC exposes you, right, and your brokerage to serious consequences, right? Obviously, without a buyer representation agreement, no commissions, and the problem is, part of our process and our checklist is we require it. Now it's a little bit where escrows are not utilizing, they're not asking. It depends on what escrow company you're working with. But here's the problem that I can see this going because if you understand the buyer representation agreement, who is responsible to pay you commission? Yeah, the buyer is responsible to pay you compensation. It says that on the document. It has a lot of explanations of what your duties as an agent is, right? And it gives you a timeline from beginning to end. So it has an expiration, but it has a lot of the duties that you as an agent will have to your client and vice versa. It also has language in there that the buyer is responsible to do, right? One, get pre-qualified, read all of the documentation, make the initial process as seamless as possible with the intent of ultimately finding and identifying opening escrow, negotiating terms, request the repairs, getting an appraisal done, right? Getting the funding that is necessary to make the deal, and then final recording of the property, and then exchange of keys, right? Transfer of ownership. There's a lot of moving parts to us to get you to the finish line, right? The Department of Real Estate investigation, potential license, discipline, or sanction. Okay. Again, this is straight out of the California Association of Realtors. This is not me saying this. This is coming out from the CAR. NAR violation, settlement agreements, non-compliance claims, right? Again, the whole purpose and the whole reason we got into this dilemma in 2024 was because there was a class action lawsuit against real estate professionals. A lot of the big major real estate companies wrote big fat checks. The National Association of Realtors wrote a big fat check as well. Okay. And then broker exposure. Now, most of your agreements are typically about 3 months, right? But you also have the ability to do an extension if necessary, right? In case you haven't been able to find, identify, or you did find and identify, but the deal fell apart, the deal fell out of escrow, and now you have to go find another property. Now you're a month and a half in, you only have a month and a half left, then you ask for an extension of time for that buyer representation agreement. Okay, meaning you can extend it. You're not just locked in to just 3 months. Okay. Now, part of that initial settlement is we're not going to hold the buyer hostage like back in the day where they would put these ridiculous agreements for 1 year. Okay. And now the buyer's pissed. It's like, I have to be committed with you for 1 year. I don't like you. I don't want to work with you anymore. Now, the beautiful thing about the agreements, too, is twofold question. The buyer can fire you, but you can also fire your client. It's a mutual understanding. You don't have to work with buyers that are not working with you. Okay. You can terminate those agreements as well. Does that make sense? Okay. But also, you can hold the buyer responsible for many other stuff too, as well, right? Just like a listing agreement, if you put some type of monetary into it, you may be able to put some type of stipulation there is, look, as part of the agreement, allow me the 30, or excuse me, allow me the 90 days to work with you. And if you terminate before my time, these are my out of pocket expenses as well. Okay. Um, we don't really see it too much on the buyer side. We typically see that more on the seller side. When you work 3 months without an employment agreement, why do you think you should do it in real estate, right? It's pretty common sense, right? We don't get paid up front. It's not like when we work with a buyer, and I'll say to Miss Bernice here, hey, we'll put an agreement together for 60 days, or let's say 90 days. But I'm going to ask for $15,000 up front. She's going to say, go pound sand, Simon. Go pound sand, right? Doesn't work that way. Honestly, it doesn't work that way. It would be nice to be able to guarantee the income, right? It doesn't work that way in real estate. We are paid in the rears. We are paid on the successful closing. And we can go 30 days in escrow and the deal falls apart. And guess what? We don't get paid 1 cent for it, right? But when the deal closes, there's significant amount of income that you can make as well, right? So keep that in mind. So best practices before showing. Obviously, the number one is obviously explaining the representation, right? Clarifying your agency role, your fiduciary duties to the buyer, right? Sitting down with them. We have an amazing conference rooms. You can come and meet with your clients here. You can meet them at their residence as well, okay? Or any centralized location, right? To sit down and really just go over the expectations, right? Part of that is explaining the compensation and how it works. Okay. Yeah, the buyer is responsible to pay you compensation. But if you understand the agreement, it also says on the agreement that if anyone credits you the compensation, right, then it offsets the responsibility of the buyer to pay you what you guys agreed to. And the beautiful thing is it can be a percentage or a flat fee. Okay. The percentage can be up to the sales price, or it can be literally a flat fee. Now, the cool thing is, and I think this is where we get a lot of confusion, is buyers are scared. We don't want to pay you a commission. I thought the seller pays. And for the most part, yes. Most of the time, you're going to ask the seller to pay you commission. Okay. So when you're sitting down with the buyers explaining the process of what you do, there should be a list of laundry of things that you do to represent a buyer. And when you explain it thoroughly, ladies and gentlemen, it's just an easier understanding is, gosh, Mark goes above and beyond that I anticipate. I didn't realize how deep into his position to help me in representing me really goes. It's what we call the value proposition. Then it makes it a lot easier for the buyer to sign the agreement. Because I get this objection all the time. Simon, the buyer doesn't want to sign this agreement. Okay. They don't want to sign it because they don't want to pay a commission. What do I do? How do I handle that? Okay. Well, you need to explain it. Because I can tell you, if I was to present it in front of your clients, I would be very detailed in the reason behind what we need to do. It's not just a loose agreement that if you want to, it's a requirement as part of the process to protect you, buyer, protect us as well through the initial process. And I get it. Not asking for you to pay, but in writing, it's part of the initial process. I'm going to work my tail off to negotiate the compensation on the seller side. And if the seller comes back with an amount that is reasonable and I'm willing to take, then I'll accept. And that offsets your responsibility to pay me. Or if the seller comes back and says no compensation, then I'll explain to you what we can do. There's options behind that as well. So there's workarounds in every element of it, right? So explaining the compensation, right? Full transparency and how you get paid. Don't hide it. Just bring it up. That's part of the lecture and the conversation of explaining the buyer representation agreement. Reviewing the BRBC. Why? BRBC. Walk through the key terms, right? I would highlight some of the elements as well. Here's this, here's this, here's this. Let's flip the page. Here's this, and this. Any questions? I would also probably give them a copy. Before you go out and do anything, here's a copy of the BRBC that I must have you agree to, right, as part of the process. Under no obligations, right? And when you go in that approach, we can terminate this agreement at any time. If you're not completely satisfied with the overall experience and my knowledge, I'm okay ripping the contract. I'm not going to hold you hostage on this. But I also want to buy in on your part as well is, we're going to be doing a lot of house hunting. You're going to be asking a lot of questions, and I'm going to address those. But I'm going to position as a great negotiator to find and identify and negotiate on your behalf a property that you love. That's where I come in. You're hiring me for my expertise and knowledge of the market, but also to protect you, buyers. This is why we have these agreements. Let me ask you, if you were in a serious issue where you need an attorney, you think an attorney will not have an agreement signed before they actually represent you? No. They want to sign something to retain them. No one works at no cost, right? Our position works a little different. We do the heavy lifting and the work, and then we get paid. Okay? But we have to have an agreement in place to protect both parties. And obviously, the last one is obtain the signature, right? As part of the agreement. Just don't give them the BRBC and just say that's I gave them an agreement, but do you have an executed BRBC, right? And if you don't, that's a problem, right? They can come back and says, well, I didn't have any written agreement. Yes, he or she provided me with the BRBC, but I didn't sign it. So it's not an agreement, right? It's not an agreement yet. How to explain it in confidence, right? Simple, professional, with confidence, right? I work under a California law, right? Before I begin representing you in open doors, we are required to establish our agency relationship in writing. The document explains my duties to you, how I'm compensated, and what you can expect from me throughout the initial transaction. Okay, simple, plain at language, every buyer understand. Don't go into the jargon of the real estate lingo, right? Get to the basics, right? The buyers don't know the real estate lingo, right? And as you get into it more and more, it's easier to kind of go away with the basic, simple, plain language, right? Professionally, right, reflects your expertise, your preparedness in this situation, right? Is how you present yourself, right? Are you confident? Do you have the skill sets? Do you understand what you're providing as part of the value proposition, right? And that leads to the confidence, right? That leads to the conversation. Can any of you meet with the client, and it doesn't matter what level of price point, right? From your $500,000 to your $50 million clientele, right? The beautiful thing is the process is always the same, okay? Just the level of conversation may be a little different, but the process is the same. Thoughts, questions so far? All right, so let's go into the changing of the compensation after execution, okay? This becomes increasingly common, and it's a major compliance issue, okay? As an example, let's say that the BRBC specifies 2%. The seller later agrees to pay you 2.5%. The agent amends the BRBC to match The amendment is a potential violation of the national settlement terms and fiduciary duties. Okay. The BRBC sets the maximum compensation that the broker may receive. You may not collect more than the agreed upon, regardless of what the seller offers you. Okay. So one, the agreement is signed, the BRBC, right? Seller offers 2.5 compensation, right? And then you amend that, right? That may be a consequence. And I'm going to go into a little bit different. How you work around this circumstance and situation, right? Because you don't want to get yourself in a situation, not that it's going to happen, but you just never know, right? Remember, we're on the scope of the Department of Real Estate. At any given time, the DRE investigators can come to a market center or an office, okay, unexpected, without an appointment, and just want to see the process. They want to see the office. They may want to pull a file, and they may just randomly pull a file. I want to see a file from last year in 2025 in October on the 15th. What closed transactions? Give me the files. And then we provide them with the files, right? So if there's any type of discrepancy with any of the documents, because they got their own checklists, right? If they see something that does not comply with it, that could be a serious violation. So this is how you protect yourself when it comes to these type of situations, right? One, all commissions are negotiable, right? All commissions are negotiable, right? We have our standard practice that depends on what your value is, okay? If you were to ask me what my compensation is, I already know what that number is because I know my value proposition. Does that make sense? Okay. Does that mean that the buyer has to agree with my compensation? No, no, not at all. Okay. Am I willing to bend a little bit to work with the buyer if it makes sense to me? Absolutely. Yeah. It depends on the situation and it depends on the price point as well, right? I'll take all of that into consideration when I'm navigating my commission. So, is in essence, let's just say that you have a 2% on the original buyer representation agreement, right? You submit an offer, okay, and the offer comes back and you're asking for more than what your buyer representation agreement. So you put on the purchase agreement 2.5% or 3%. And then the seller agrees on the purchase agreement to honor that 2.5 or 3%. Okay. And you ultimately get the offer accepted, right? Open escrow, you're excited, you got what you wanted, but you forgot to amend an agreement, and that agreement is your BRBC. Now, two of the elements here is if you look at the scope of all that, right, and this is where it can cause a problem is you're not disclosing that to the buyer. So in essence is when someone is willing to pay you more than what your buyer representation agreement, the seller cannot do that. The seller needs to pay you what the buyer ultimately has an agreement with you. Does that make sense? So the seller cannot pay you that additional percentage because that's a violation. This is why, ladies and gentlemen, when I'm discussing these agreements, you want to always go with the maximum agreement with the buyer. Well, Simon, they're not going to sign an agreement. Well, did you really explain it to them and how it works? For me is if I was representing, I would do 3%. Okay. And if I'm going to be asking for any compensation on the seller, I'm going to ask the maximum of what my buyer representation agreement says, which would be 3%. That way, if the seller pays me the 3%, I'm in agreement and compliance with my BRBC. If the seller says, no, I'm not going to pay you 3%, but I'm willing to pay you 2.5%, okay, which is within compliance, right? Because the buyer agreed to pay me 3%. The seller stated that they only will pay me 2.5%. There's that 0.5% discrepancy, right? Who would be responsible to pay the difference? Why?
Because they agree. They agree.
That's right. The buyer would be responsible to pay you the difference. Absolutely. That's within compliance. Okay. So yes, you can collect commissions from both the buyer and the seller. 2.5 from the seller, and then the 0.5% from the buyer for a total of 3%. That is okay. I can justify that if we ever get audited by the Department of Real Estate. Okay. The problem is when we don't communicate that and we ultimately accept more than what the buyer representation agreement, and that's really where the problem has occurred, and that violates the National Association of Realtors, right? So when it says the improper amendment, right, it's not fully disclosing that to the buyer. Now, let's kind of flip the tables, right? And let's say that you do go with a lower commission, right? So meaning that the same scenario, you have a 3% BRBC, you submit an offer asking the seller to pay you 3%. The seller comes back on a counter offer and only offers you 2.5. You have a 0.5% commission that is technically responsible to pay you as the buyer, right? But you don't want to charge the buyer that amount. Okay. What can you do? What can you do? You're okay with the 2.5%, ladies and gentlemen?
You amend it.
Absolutely. Thank you. You do what's called a modification of the buyer representation agreement, basically amending that agreement from your 3% down to 2.5%. That now is in compliance. Okay. Most agents will be okay with that because they're still getting a pretty decent commission out of it, and they don't want the burden of the buyer coming in with additional money to pay you, even though they're responsible to pay you the difference. You can amend that agreement and do it correctly by asking on this agreement that you're reducing your percentage from 3% down to 2.5%, and you have the buyer sign it. That protects the buyer, and that also puts you in a good compliance if we're ever audited by the Department of Real Estate. That's the proper way. Okay. You cannot do a 2% BRBC make an offer asking 3%, and then seller comes back and offers you 2.5%, but you still have a BRBC for 2, and the seller pay you 2.5. That's a violation. Okay. Now, what can you do in that situation? Well, based on the NAR settlement, you should have started off from the very beginning going with the 3% commission total on the BRBC. Now, what's so funny is, ironically, it works okay on the reverse. It just doesn't work on the other way around. You know, they don't want you to do that, right? They don't, because you're basically not being truthful when you submit an offer higher than what you agree with the buyer. So that's where the dilemma, and that's where they're trying to catch agents, is like, I'm going to try, and then I'm going to try to amend it and work it because I was able to get more from the seller. That's not the intent of this agreement, and this is why this presentation here talks about the violation of it, right? You cannot do that. That's not what you want. They want you to do is, yeah, it makes sense, right? It makes perfect sense. Well, they offer more commission. I'm just going to amend it to a higher from a 2% to 2.5, and the buyer sign it because we know that the seller's going to pay. But that was not the intent. You went behind what the original agreement is, and that's where the National Association settlement comes into a violation, because you're not fiduciary doing your responsibility, and that's what it can expose to a litigation, in my opinion. Okay, so, that's just the way it is. Yes, sir.
Simon, what if I sign with one buyer, buy a bank, and then later there's a buyer, BE joins. So does that notify and validate the original fully executed BRBC?
I'm sorry, repeat the question.
So what if I signed an agreement with one buyer and then that buyer takes on another one, so let's say a couple. And then, or maybe a sibling or a friend. So originally buyer B is not in the picture, now buyer B joins. How does it affect the BRB?
Got it. Very good question. So you're basically have an agreement with one buyer, right?
Yes.
And then now someone wants to come into the picture, right?
Or
Oh.
the first buyer brings in.
Yeah.
Second buyer.
Yeah, good point. So the answer to put it into retrospect is really very simple. You're going to have to do a modification of the buyer representation and adding this new buyer into the agreement. Okay. So from one buyer, you're adding a new person. You're going to do a modification of the buyer representation and adding the second buyer to the agreement. Now, that agreement can be the same. Maybe you already spent a week or a month with this particular buyer. We're now adding someone else. That agreement doesn't modify until both mutually agree to extend it because you're adding someone else, right? But the issue is the longevity of the agreement, right? Because once you add someone, and let's say you're close to the expiration, then adding that person, you have to get both agreements, both mutual agreements to extend it, not just from the original, right? When you add someone else to the buyer representation agreement, right? So can it be done? Absolutely. You can add multiple people. It doesn't have to necessarily just be one. It can be, two or three people, but the way to do it is through a modification of terms. Okay, good question. All right, so the compensation rule, right? For the BRBC, full negotiable, right? Compensation is negotiable between the broker and the buyer, not dictated by the market, right? It's not what the market. So you cannot say, this is what the market dictates on the compensation. This is between you and I. Okay, if you're the consumer, I'm the agent. Whatever you believe is your worth is typically right. And I hear this quite often. Well, the standard practice, right? And yes, I'm pushing 30. Mark, how many years are you pushing now in real estate?
Couple.
Couple, yeah. It's pretty much been kind of the standard, right? 2.5, 3% is typically the standard that we see, right? And we hear it, but it doesn't necessarily have to be your standards, right? It's between you and the buyer. If the buyer is okay, you're okay with it. That's the agreement. Does that make sense? Okay. So must be in writing, right? Any agreement compensation must appear on the BRBC, right? So everything is documented, and before it's an accepted agreement, it has to be signed by the buyer, and it has to be signed by you as well. Okay. Cannot exceed the agreed amount, right? If the seller pays more than the excess credit to the buyer, the broker keeps only the agreed upon, right? Not necessarily the additional amount, because the BRBC has this number. That's the number that you must collect, not anything above that, because that's considered a violation. So if you increase your fee after execution, your buyer may ask what the additional services that you provide for the extra money. Okay, so you don't want to be in that position and compromise where now opens up a opportunity for them to try to challenge, right? And this is why it's also, again, folks, very important that you have an agreement in place, because if you don't, then it's easy for them to go and work with someone else. Okay. And remember, there's two components to the agreement. There's the exclusive, and then there's the non-exclusive agreement, right? You always want to get the exclusive agreement because it gives you a little bit more protection than the non-exclusive agreement. So I want you to be mindful about that as well. Set your fees right from the very beginning, right? So know your value, right? Understand what full representation is worth and articulate it clearly before the relationship begins. Charge your value, right? Don't underprice hoping to fix it later, right? Rarely comes, and fix creates complexity and risk involved, right? Honor your agreement, right? So once signed, honor that agreement. It's a commitment between you. Your clients would appreciate you even more, right? So the assumption is know your value, set the fees, and honor your agreements, right? I mean, it's pretty common sense, right? Any questions, thoughts, or concerns regarding this? Okay. Buyers want a new agent, right? This happens constantly. A buyer walks in and says, I fired my old agent, right? Critical question. Did they actually terminate the agreement, right? Just because I said I fired you, that doesn't give me proof or receipt, right? In most cases, right? In most cases, you cannot just take something that you bought without having a receipt, right? That you bought this at a store, right? It depends on the circumstances, right? But mostly you're going to need proof of receipt that you pay for a merchandise before you return it, right? Because we don't know what, when, or where you bought it, right? Well, the essence is the same thing when it comes to a termination of agreement, right? Are you asking the right questions? Most of the issues is during open houses, right? You're hosting an open house, you're getting traffic, you're getting people coming in, you vibe and you connect with someone. This is why it's important to have some type of registry, right? That gives you information to put their name, their number, their email address. Are you currently pre-qualified, pre-approved? Are you working with a lender? Are you currently working with a real estate agent? Yes or no, right? Because then that's just the tone of what you can and cannot say as well. So it gives you an opportunity. If they say no to the question, are you working with a realtor? Then you're open to try to work with them, right? The goal of open houses is to find clients, right? And help with opportunities, right? But if they are working with an agent, does that mean you're radio silence? Your hands are behind your back. You're not going to say anything because you're afraid to do or say something. Is that also something that you need to do? The answer is no, right? Common sense, right? Because sometimes buyers will not tell you the truth. Okay. They will not tell you the truth. They do it to avoid any additional conversation because they really are just looky loos. And I get it. You're going to get people that are just curious. They're not really in a position to buy, but they're curious about the house, right? And you're going to get people that are going to say, yeah, I'm working with an agent. Don't talk to me. But as an agent hosting an open house, you still got to be proactive. I still want to know because I've seen and I've experienced where they say yes, and then ultimately, no, I'm not really working. I just said it just to say it, but I'm truly working, truly looking to buy something, right? And we both hit it off, and now you just have a client. It happens. Trust me, open houses are gold mines of opportunities if done correctly. Always ask these questions, right? Is there any other agreements that you have? Have you signed a buyer representation agreement with another agent? Exclusive or not exclusive, right? The type of agreement determines the buyer's obligation and exposures. Was it canceled in writing? Verbal termination are not sufficient, right? Just because I say I fire you doesn't mean nothing. I want to see proof, the receipt. Tell me, show me, so that way I can now navigate if I can help or not help, right? Because if you don't have an official signed agreement and a verbal doesn't hold water, right? You're not going to go on a listing, right, and put a property on the market when the seller says, yes, list my home, put it on the MLS. Okay. What agent is just going to put it on the MLS just because the seller verbally told you to put it on the MLS? No, you want to document it. And how we document it is by an executed listing agreement in place. Do you have a copy, right? Request a cancellation document before proceeding with any representation, right? All you're doing is just protecting yourself from any potential, because here's the problem that we see quite often. Okay. What we see is that the agent is working with someone because the buyer said they're not working with any other agent. Then you get a call from an agent saying, hey, by the way, Mr. and Mrs. Smith are my clients. Why are you talking to them? I have an agreement with them. Wait a minute. They told me they had no agent representation. Well, no, I've been working with them for the last month and a half. Okay. What can you do in those circumstances? What should you do or say, right? I like how he thinks, but you got to be very careful, because if this this agent believes you are compromising, they can file an ethics complaint against you for interfering with their clients. Be careful. Mm-hmm. Absolutely. I get it. I get it. Now, are you going to take that for face value?
Yeah.
Okay. So what can you do or say? You know?
They told me like they didn't have anything. I mean, when you let them go, but I'm also going to split if you want to work.
Well, this is where you have to be proactive, right? And if they say no, they're not working with an agent, I'm going to believe that they are not working with an agent. Who am I to say that they're lying to me, right? If they say no, I get it. I'm going to go with emotions. I'm going to try to lock them in and work with me, right? And if an agent comes back and says, well, I have a buyer agreement in place, they specifically told me that they were not working with anyone. Who am I to dictate anything different? Okay. Then you have a better position to arm yourself and says, look, if you have a problem, why don't we jump on a three-way call with the clients and hear it firsthand? If the buyer is willing to do so, that way we can, oh, you know what? This was an agreement. They're just sometimes upset and they're just trying to find an avenue to hook themselves on something, right? Again, there's so many different situations and scenarios that happen. Be mindful, protect yourself, ask a lot of questions, and make sure that if they say they're no longer working with someone, get the proof. Show me the proof. Yes, sir.
What is some cultural practice like they're used to, like casting a wider net by signing multiple events, and then without, purposefully, without really saying whoever catches the fish and gives to me, then I'll pay.
Yeah.
So
Good question. Yeah.
So is it like maybe the arbitration, whoever signs first, and
Yeah, that's a good question. So the question asked is, what if this buyer had multiple agreements with multiple agents? Okay. Well, it really depends. Can the buyer have multiple agreements with multiple agents? Everyone say yes. Why would they do that? It's beyond me, because they would be responsible to pay compensation. Now, what sets this agreement little different, Matthew, is this: is it an exclusive or is it a non-exclusive? Because on a non-exclusive, I can put very detailed agreements in place that I am only looking for a specific property, a specific city, or a specific price point or terms and conditions. And if this agent doesn't find these agreements in the parameter based on that agreement, then I am not responsible to pay a commission. Okay. And I can go with multiple people, like an investors, right? That are saying, look, if you can find me a good deal, I got an agent working in the city of Terrace, as an example. I have someone else in the city of San Gabriel, right? You can be very specific and calculated as a buyer working with multiple agents, but also specified on those agreements. Look, I will only work with you if you bring me and I ultimately submit an offer because you brought me an agreement. Then yes, then I can say that I am not entitled to compensation, even if I'm working with 10 real estate agents. Does that make sense? So as a buyer, yes, I can have 10 agents working for me, but I want to be crystal clear in my approach that if I'm going to be working with 10 agents, then I'm going to be very specific in how they write those agreements. One, I'm not going to say it's an exclusive, because an exclusive means that if I find and identify a property, I'm still responsible to pay that agent a commission. I will not do an exclusive. I will do a non-exclusive with stipulations. Does that make sense? And then that's my exit strategy, because if this agent finds and I submit an offer, then I am not responsible to pay the last 9 agents any commissions. Does that make sense? Good point. Good questions. Why it matters, double commission risk, right? And that goes into this, right? If another broker still holds an enforceable agreement, your buyer may owe compensation to 2 brokers simultaneously. And that can happen, right? Commission disputes. Broker 1 pursues their contractor compensation even after you close the deal. Ethics complaint, as I mentioned, right? Interfering with the existing client relationship in a NAR code of ethics violation. Litigation exposure, both the buyer and the brokers may face legal action from a prior broker, right? The brokerage may want to pursue the agent and also the buyer in these cases. So, be mindful on these circumstances. If think before you work with this buyer, right? So broker compliance, right? Ask if the other agreement exists, request a copy of the agreement, review the cancellation documentation, determine exclusives versus non-exclusive, right? If uncertain, call the broker, right? Call your leadership team, and we can help navigate that, right? Just a critical reminder, agents are not attorneys, right? So don't interpret or enforce cancellation rights or legal consequences for your clients, right? If you don't know, bring it to our attentions and we'll help you navigate that, right? That's always going to be the best case situation and scenario. Additional BRBC mistakes we see beyond the 3 core problems is representation periods, right? Again, left blank, okay? If you leave things blank, that's vague. That can give the buyer an exit opportunity. Anything that is missing may be an avenue for the buyer to articulate their position not to pay you compensation. So don't be in that predicament or situation where now you're exposing yourself, right? So be mindful and careful on that. Every buyer file must contain the BRBC, the agency disclosure, the PRBC, which is the possible representation of more than one buyer and seller, right? The buyer contingency advisories, the transaction notes, all of the above. I think we all kind of know that. And this is why you should also hire a transaction coordinator to keep you on track as well. 5 questions that prevent most compliance issues. Are you already working with another realtor? Have you signed a buyer representation agreement? Are you comfortable reviewing mines before we begin? Have you been pre-approved by a lender? What are your goals and your timelines? The BRBC is more than just a form. It's an agency agreement, your compensation agreement, your compliance agreement, and your risk management agreement, right? So the beautiful thing about this particular form, it provides you with a lot of protection, but it also positions you with compensation when you close successfully the deal. Okay. The best agents do not avoid the conversation. They lead it confidently, clearly, and every single time. So with that, any additional questions? That's pretty much all of the presentation. Yes, sir.
What about a dual agency situation where you have a listing, buyer comes in, he does not have a buyer broker?
Yeah.
You need to establish one if you're going to
Good question. Okay, that's a very good question. So dual agency is basically stating that you represent the seller, you have an exclusive agreement with the seller, a buyer comes in, is not being represented by another agent, you sign a BRBC agreement, then that ultimately, for a dual agency, that creates a dual agency once the offer gets accepted. So once the offer gets accepted, because you submitted an offer on your buyer's behalf to your own seller, then that opens up a dual agency. Okay. Um, but you don't have to have a dual agency. You can do what's called a non-represented agreement as well. Meaning you can be the listing agent. On the listing agreement, there's language in there that says that you can charge the seller additional compensation to represent a non-exclusive or a non-represented buyer on behalf of the seller for paperwork trail to get the seller to the finish line. Meaning I charge 3% to list the home. I can also charge another 1.5% to 2% to represent a non-exclusive buyer on just paperwork, meaning I'm just doing the paperwork, but under no circumstances am I tied to the buyer. I have no fiduciary duties to the buyer, but I can do the paperwork on behalf of the buyer just to get the deal closed for my client that I do have an exclusive agreement. And I can charge additional compensation. Meaning I don't have a buyer agreement with the buyer, right? In essence, because it's a non-represented, right? And that's the loophole in the stipulation that allows us to work on behalf of one principal, not the other, but it's really just the transactional component of it. Because in our position, we never represented the buyer. I represented the seller. We clearly stated that on the agreement. The buyer had every right to speak with an attorney, speak with an agent, get guidance from someone else. I'm just pushing paper, and the buyer ultimately would have to find their own avenue of explanation because I am not representing the buyer in this case. And that's allowable.
So that makes the seller more comfortable with us, right, in a sense.
Yeah, because it's not a dual agency. You're not exposing anything to the buyer because you're not protecting the buyer just as like you would on the seller. You're only just transactionally doing paperwork on behalf of your client, which is in this case the seller. But under no circumstances are you actually working with the buyer. That doesn't create a dual agency.
I have a case coming up probably next week because the potential buyer, I have worked with her for multiple years. And then she's into running a volunteer home business. So she brought me to this potential seller who's closing the business and wanting to sell the home. So this potential buyer kind of alerted me, and I went to visit the home in Laverne. And then also I got in touch with the owner, and the owner confirmed that. And so we have an appointment on Tuesday. So I'm debating what to do with the buyer because the buyer is very much the finder. And I also know that, she probably wants as cheap as possible because she can afford it. So then I'm thinking this non-representation approach might be more appropriate, right?
That's correct. Yeah. Just because once you have an exclusive agreement with the buyer, then now you're responsible to navigate that as a representative agent in this case. So to keep it neutral, then yeah, you don't want to have any type of representation agreement with the.
It shouldn't affect my
No.
commission, right?
No, not at all.
Okay,
Not at all.
thank you.
All right, team. Well, that concludes our class. If you have any questions or anything regarding this presentation, please feel free. If there's no other questions, have a wonderful afternoon and a great weekend, everyone. Thanks again, and I'll see you on the next contract class. Thank you.
Thank you, Sam.
Thanks, Simon.
Oh, you're welcome. Thank you. Let me stop recording real quick.